Good afternoon, and welcome to Broadband Breakfast live online for Wednesday, October 7th, 2020. I'm Drew Clark. I'm editor and publisher of Broadband Breakfast, and here to welcome you for what may be, at least for now, our final Champions of Broadband series in our webcast series. This has been a great and fun exercise to interview people from Jim Baller to Tom Hazlett, from Mignon Clyburn to Rob McDowell. We've got another great expert lined up here, whom I'll introduce just momentarily. But before I do, I want to remind you to please subscribe to our twice weekly newsletter on broadbandbreakfast.com. You can stay up to speed on what we're posting and talking about at Broadband Breakfast, and also to share this this link and this discussion with your friends on various social media where you're watching. This is, as I said, our last Broadband Breakfast live online Champions of Broadband, but we're moving immediately into a new series on 5G. It's called a no-nonsense guide to 5G. We just announced it. It's at the top of broadbandbreakfast.com right now, so I encourage you to check it out, see more about this series, and it begins next week, Wednesday, October 14th. So with that, let me go ahead and introduce our guest. He is Randy May. Randy is the founder and president of Free State Foundation, which is a free market oriented think tank that he founded in 2006. And he's also been involved in other organizations like it in the past. Let him talk a bit more about that, as well as an extensive role with the National Academy of Public Administration and the Administrative Conference of the United States. So those are the perfect things to put our audience to sleep, right, Rand? But seriously, we are really excited to have you on this discussion, Rand. I've known you for more than 15 years. In fact, this year is something that Randy was quite involved in producing, the Digital Communications Act, and we're going to hear more about that from him. But for now, let's go ahead and turn it over to you, Randy, to tell us a little bit about yourself and some of the thoughts you've had. We've obviously had conversations about the background that you bring to studying telecommunications law and policy and how it should be changed, updated. So over to you, Randy.
Well, first of all, thank you for having me, Drew, of course. And I hope this is a case of last but not least, because I know you've had some terrific speakers in this series. And congratulations to you. I just want to say quickly, I have known you for a long time. I think it's actually been 2 decades, and I've had a chance to follow your career through your own trajectory, and you've done really some fantastic things, and this Broadband Breakfast website and everything associated with it really is quite terrific. So congratulations to you, Drew.
We're going to have to quote you and put that on our next Rand.
Well, that's fair. That's fair enough. So look, I first got involved in communications law and policy 45 years ago, actually. It was 1975. I was with Steptoe and Johnson, a law firm in DC, and started to do a little communications. So what I want to do, and what I asked Drew for permission to do, is just take 5 minutes, and I'm going to hit some high points during just really at a high level, some things that stick out in my mind over those 45 years, skipping a lot of years. And then I think that'll provide some good context for our discussion going forward. So in 1978, I joined the FCC as assistant general counsel, and in late 1979, I became associate general counsel at the FCC. and I ended up leaving in the spring of 1981. But while I was at the commission, I think the two most important proceedings during my time there, and I worked on both of these proceedings to some extent, were the Computer 2 proceeding, it was called, and competitive carrier proceeding. So just very briefly in one line, I'm going to tell you what they were because they do provide a frame that's useful, I think, going forward. So the competitive carrier proceeding was the first time that the FCC was trying to figure out how to reduce regulation over acknowledged common carriers, as there were new entrants into the marketplace like MCI and Sprint that were in fact common carriers. And we established the principle, the theory of forbearance in that competitive carrier proceeding. Then on the other hand, in Computer 2, a real landmark, that is the proceeding that established the distinction between basic regulated telecommunication services and enhanced unregulated information services. And, in a nutshell, enhanced services to fall into that unregulated category had to have an element of computer processing. So that was the FCC in that time frame. I left in, as I said, in 1981, and shortly thereafter I started to represent CompuServe, which was one of the early online consumer services. We didn't have usernames. We had numbers like 76003, blah, blah, blah. I can almost remember mine. And I represented CompuServe for actually the next 15 years. Then we had the AT&T breakup in '84. I was involved in that proceeding, representing CompuServe and a few others. And the main concern then for many of us, including myself, was constraining the market power of the Bell, what we called the baby Bells, the Bell operating companies, that were being separated from AT&T, which, remember, AT&T was given the long distance business. If some of you can remember what long distance implied at the time. I'm going to skip ahead then to 1996, the Telecom Act of 1996, that landmark act. And right now I'm only going to quote to you the preamble and say no more. The preamble of the Telecom Act said that its purpose was, quote, to promote competition and reduce regulation in order to secure a lower price and higher quality services for the American telecommunications consumers, close quote. Now, in 1999, remember Bill Kennard was chairman. I think he was, in my book, an excellent chairman. He was Bill Clinton's appointed chairman. He issued a strategic plan for the FCC called A New Direction for the 21st Century. I don't think a lot of people now remember it if they ever knew about it, but at the time I thought was important. It made an impression upon me. And the first two sentences in Bill Kennard's report stated as follows, quote, in 5 years, we expect U.S. communications markets to be characterized predominantly by vigorous competition that will greatly reduce the need for direct regulation. The advent of internet-based and other technology-driven communication services will continue to erode the traditional regulatory distinctions between different sectors of the communications industry. In October 1999, that same year, I left private practice of law, and I joined the Progress and Freedom Foundation as a senior fellow, a free market-oriented think tank, focusing on communications policy. And that's where we undertook that project that we're going to talk about. And then in December of 2000, I think this is important, Michael Powell, he was then a commissioner in December of 2000, a few months later became the chair of the FCC. He gave a speech titled "The Great Digital Broadband Migration" that I think is a really important speech that bears looking at sometime again. But Powell said, really, he talked about how already at that time there was a migration from analog-based platforms to digital platforms. And Powell said, rather than talk of reform, a relatively pedestrian incremental notion, we need to consider the Schumpeterian effect on policy and regulation. That is, what are the implications of creative destruction economics on economic regulatory policy? Then just two more items. In 2005, while I was still at PFF, I invited then a relatively unknown academic at Vanderbilt Law School, a professor named Christopher Yu, now quite well known, to speak on net neutrality, which was already heating up as an issue then. Remember, that was 2005. 2006, I started the Free State Foundation as a free market-oriented think tank focusing on communications policy. And then the last thing I'll say before handing it back to Drew is that during the lifetime of the Free State Foundation, so let's see, 2006.
Can I jump in, Randy? I want to get to the Free State Foundation a little bit, but let's stick before the 2000 for a minute, if you don't mind. And I really do appreciate your highlighting. I'm going to kind of just play around with the mics for a second here. I really do appreciate your highlighting the role you played, which I did not know, in the AT&T case and the CompuServe role, and that's very illuminating. But so in this this time frame, 1996, and the Telecom Act, which again, appreciate your citing the importance of competition, and that's so much what I remember when you were involved in this project, the DACA project. But let me ask this question: what was the need in 2005, 2006, which was 10 years, after the passage of the Telecom Act? Now we're nearly 25 years. What is the need for revising the Telecom Act? What in your mind is motivating or driving, if you still believe this, if you still believe there needs to be an overhaul of the telecom law? Why do we need that overhaul? Go ahead,
Good. Well, I believe we need it more now than in 2005. So I can state that unequivocally. But even then, I thought that we needed it. And by the way, I just want to say that project, and you've held up the DACA thing, which was great. That was a project I did head it up, but there were a lot of academics that were well known, as you know, that worked on that project, a whole bunch of them. But already at that time, Drew, it was clear that the structure of the existing act, which in this way was not changed by 96, as you and most of the, I'm sure our viewers know, the current act has what we call a stovepipe or stovepipe structure. Right. Where you have broadcasting in one title, cable in another title, common carriers in another title, and they each have their own regulatory regime, their own regulations that apply in those stovepipes, right? And what was evident already at that time was that because of technological and marketplace convergence, that resulted and was enabled by the move to digital platforms, the distinctions between these services in terms of the way they ought to be regulated was eroding, right? I mean, if you look at the existing act and you pull out the definitions, we could go into them if you wanted to, but when you pull them out, they're really based on what I called at the time, back in 2005, techno-functional constructs, meaning that they were really based on technology distinctions, and they were based on functional distinction.
So let's take a minute to talk about this. So obviously in the Telecom Act we have our Title II, which covers, you call them common carriers. We may want to put that term. Telecommunications services that traditionally were wireline based.
Mm-hmm.
That's what Title II is all about. Title III, of course, is for the wireless and the. I mean, obviously it's broadcasting, but now we think of it in the wireless.
Right.
Title VI, I believe, maybe V. It's kind of a little confusing.
Six.
Numbering goes is for the cable industry. Now, clearly, those are all things that have converged, no doubt about it, right? So then the big question in the room is the difference between the Title I information services, the deregulated, the less regulated. What is the appropriate distinction there? Because this is obviously leading us into the heart of the net neutrality controversy that continues to be a controversy today. And so I would ask you, like, if we strip out the techno-functionality breakdown, what would you do? Would there be a layer, a transport layer?
Yeah, and look, the way I want to answer that is just go, and it does answer, is go back to what we proposed. I told you what was wrong with the Act, 96 Act, and what we proposed in DACA, Digital Age Communications Act, which I think is still the correct answer, and it goes into then net neutrality, is that you replace that structure with a act that number one, it gives the commission retains jurisdiction over all forms of electronic communications. So we weren't stripping the commission of jurisdiction, but before exercising that jurisdiction, regardless of the technology, Drew, the commission would have to have convincing evidence that there was a marketplace failure and that there was consumer harm. And that was at the heart of the Digital Age Communications Act. And, so it replaced the broad public interest authority, which runs throughout the Communications Act, with this, what I would call a competition standard, Drew. And the competition standard, is like antitrust. We said at the time, and I would say now, it doesn't have to be strictly, you don't have to transport all antitrust jurisprudence absolutely strictly into the Communications Act standard, but it would direct you to using economic analysis to determine market power, and therefore to determine whether you should have regulation or not. So that's sort of the capsule answer.
Okay, well, if that's the answer, Randy, why do we even need an FCC? Why is all aspects of the FCC just handled by the antitrust division at the Justice Department or FTC?
Well, for one thing, and this I think doesn't get directly to where you're going to have, but we need an FCC because of a lot of spectrum matters that are outside of what we're talking about right at the moment. That I think I would rather have a specialized body with some independence.
Okay. Well, putting that aside, are you saying that absent spectrum, everything else kind of goes outside of the FCC's jurisdiction?
No, I didn't take that position. There are, as you know, a lot of people that do, and even among our DACA group at the time that we did it. And you were such a crackerjack reporter, you probably got inside of this, but there were some that took that position, but the consensus was that there was still a role for the FCC to play because it would have specialized knowledge and expertise about the communications industry, the technology that would be useful in making. It would still be making the assessments, as I said, based largely on an economic analysis that was antitrust-like in terms of the way you look at consumer harm. But the answer was that it was useful to have this body with the specialized expertise. I think I still feel that way, but to be perfectly candid with you, there are arguments, and they're probably stronger now than they were back in 2005 as to why, for that part of it, putting aside the other part, you couldn't let it just be, fall under the antitrust realm. And of course, to some extent, let me just add, to some extent, in this, we'll circle back and wrap our hands around it. But to some extent, the FCC, right, in the Restoring Internet Freedom Order, that's what it essentially did, right? It left, it took the position that, except for the transparency requirement, it was going to leave a lot of the enforcement and regulatory authority over to the antitrust authorities and to the FTC.
All right. So, Randy, I'm going to go to ancient history, i.e., yesterday, right? Because what happened yesterday is the FCC responded, or maybe Monday, 2 days ago, to the requirement that was imposed on it a year ago. Also, exactly a year ago, the DC Court of Appeals, in their decision in Mozilla versus FTC, said, "Okay, we'll grant you do have the authority to repeal these net neutrality rules your predecessor Tom Wheeler put in place at the FTC." However, it was a very unique and strange decision. I wrote a piece about it. I'm going to cite a piece of my piece, just quote the judge's decision, because what the judges, Curiam, wrote about poll attachment speaks to what I want to ask you about, Randy. Okay, and so basically, the the DC Court of Appeals remanded to the FCC 3 issues: public safety, lifeline, and poll attachment. And they said in their mandate or remand to the FCC that this whole regulatory scheme applies only to cable television, talking about poll attachments, only to cable television systems and telecommunications services, categories to which, under the FCC's 2017 order, broadband no longer belongs. And then it cites sections in Title II, 224A, for defining poll attachment as attachment by a cable television or a telecommunications service provider. So my question to you, Randy, isn't there some sensible distinction between a telecommunications service and an information service, in which a telecommunications service should be regulated differently so that you can have these obligations, that benefits and obligations that are associated with being on the transport layer? And one of those is the poll attachment, right? Because that's part of Title II of the Telecom.
Drew, number one thing I'll say is I've done my damnedest during all of those years I talked about to pretty much as I could stay away from the poll attachment section. What is it? Because it's so complex. So I couldn't even tell you that much about the poll attachment law, but I can tell you this, and I think is really the answer to your question from my point of view. Because you ask about, you're trying to ask, or you did ask, whether there's a distinction that ought to be meaningful today between telecommunications, I think, and information services. I think that's really what you're asking. And what I would say is, no, that there shouldn't be going forward. That's the law we have. That's the act we have. But this goes back to what I was talking about. Now I'll explain why. I mean, I've stated this, 15 years ago, I wrote a piece called "The Metaphysics of VoIP." You're familiar with Voice over the Internet Protocol. That presents a good question of a service and the FCC to this day, right, has never definitively come down and ruled whether that's a telecommunication service or information. Let's just think about that for a minute. The FCC hadn't done it. But you know what I said back then in 2005 in an essay I wrote for CNET? I said, really, that we shouldn't be relying on these definitional constructs that I call techno-functional constructs. What we ought to be looking at is health service, whether there's competition in the marketplace. So this takes us back to what I talked about, earlier, and which you've honed in. Let me finish for you. And the distinction. So I don't mind admitting to you that when you look at the Telecom Act and look at the definition of telecom and you look at the definition of information services, I've got them here weekly. They're really the distinction, and particularly when you try and determine what's computer processing, enough computer processing, they're metaphysical in some sense. Jesuits could have a good debate about it. But what we need to do is be focusing on whether there's competition in the marketplace that is enough or not enough so that we have regulation.
Well, look, I think the techno-functional point is obviously a good one, and I think that it does seem strange. We still have, Title II, Title III, Title VI dealing with different, you might call them applications, but I guess that is really going to my question, which is to say, isn't there not something? And I don't know if the reason is because it's in the right of way, it's in the public right of way. Is there not some reason? You already answered this, Randy, so I'm going to kind of ask it a different way. Is there not some reason to say that one portion of the telecom layer should be regulated differently, i.e. regulated, and another unregulated? I mean, isn't that what your Computer 2 training was all about, saying this should not be regulated, but we're going to distinguish it from this thing that is legitimately regulated? You're just saying, let's just push all that deregulation over to the thing that originally was to be regulated and not do any regulation. That's kind of what I'm hearing you say, Randy, right?
No, I didn't say not do any regulation. I was pretty careful about that. But I am saying again, and this is, I hope people will think about it. I know you will, because I've been straightforward. I think Computer 2, I wouldn't today defend. I think Computer 2 was really important at the time, along with competitive. It was useful. It was sort of, we talk about other things we've done in telecom, with nascent emerging providers and why we did those. And that has to do with access charging computer. That was not, I don't think that distinction is now in the Telecom Act of 1996. And I did work on it at the time at the FCC. But I don't think it makes sense now for the paradigm that we ought to have to regulate communications. I know there are others that would disagree, but I think I think you've got to take a forward-looking view of these things. And in my view, I mean, the one thing that unfortunately, or fortunately, I'm older than a lot of people that'll be viewing this. And I've seen all these changes, honestly, in communications. They've been drastic and they've been dramatic. And frankly, when I was in private practice, but private practice is different really than a think tank, but I represented, like I said, CompuServe. I represented large users of telecom service. We were always fighting with the Bell companies. And I have no qualms about that. CompuServe, until the day I stopped representing them, they always thought they were worried about, the market power, and then they were taken over by AOL. But no problem. But one of the, I did see that there were, I've witnessed these changes in the marketplace, and I think these realities, you have to take them into account. So the way the 96 Act was framed, I don't think is the proper way for communications now.
Well, let's take a different tack. Your mention of CompuServe prompts the discussion. I mean, nowadays people are remembering CompuServe for a different reason entirely. Its role in Section 230 debate. I mean, this is a raging debate that was very quiet for many years, and obviously CompuServe did not have a very active moderation policy, whereas Prodigy, their competitor, did have a very active moderation policy. And Stratno's case, they got basically rebuked for that. I mean, they got liability for Prodigy, that is, for moderating. And along came Section 230 in the Telecom Act, part of the Communications Decency Act, which of course got appended to the Telecom Act of 96. And it basically said, hey, we're not going to penalize you, internet service bulletin board provider, for moderating some degree, but not to another degree. And now it's an issue. So, Randy, I want to ask your opinion on this issue. Does Free State Foundation take a position on issues like this? Do you take a position on issues like this? I mean, do you kind of think there's any legitimacy whatsoever to President Trump's request through the National Telecommunications and Information Administration to get the FCC to take jurisdiction over definitions in Section 230?
Yeah, let me say a couple of things. We actually filed comments, and give me a chance, if you would, to explain, because I know you're passionate about this. I watched your previous session with Commissioner McDowell, which was informative too and interesting. So one thing I want to say is when I say that we filed comments, and you said, does the Free State Foundation take a position? We actually, every time we file comments, we have a note at the bottom, right at the beginning, that says these are the views of the filers of the comments, and they shouldn't be attributed to everyone on the staff or so forth and forth. So that's the first thing I want to say, and that's, I think, good practice, because we want to encourage people to have their own views. In this case, I filed comments along with my colleague Seth Cooper, senior fellow at the Free State Foundation. So, and it sounds like you haven't looked at, maybe you haven't seen.
No, I'm sorry, I haven't yet.
Okay.
We did report about it.
No apologies necessary. But here's what I said in those comments, and we filed reply comments, which I think even refined the position, perhaps. But number one, I do think it's quite possible that the FCC has authority to consider the NTIA petition, but only to this extent, or this is the view that we took, that it could issue clarification, it could issue its views in a declaratory order or something akin to that, which would give its interpretation of what terms in Section 230 means, and then really they would be it would be up to a court to ultimately, it is up to a court to interpret it. It's possible the FCC's views might get Chevron deference. That's something else we can talk about later. I'm not really a fan of Chevron deference, but they might get. That was one part. But here, the second part, to me, it was important, and it's not now maybe the prevalent view or even the popular view, but I hope you and others will take a look at it and think about it. On the First Amendment, that's a big part of the discussion of this Section 230 issue, as you know, Drew. And my view is that any narrowing, and one thing we said, to be clear about it, and this is, I'd much prefer, I wasn't advocating, when you read our comments, you'll see they're trying to explain a view of the FCC's authority in the First Amendment without advocating the FCC necessarily do anything. Congress is the proper body to consider, in my view, whether something should be done. But here's what I said, and this would apply if Congress acts or the FCC. Any action that reduces the immunity of the online providers, that's not necessarily a First Amendment violation. They weren't entitled, as a matter of First Amendment law, to have immunity granted in the first place. I think the law made sense at the time. It's another one of those things, we could talk about others where you do something to help get a marketplace segment, an industry off the ground, nascent. So I think it was probably a good decision, but that doesn't, in my view, mean that it shouldn't be re-examined now in light of the marketplace today. But on the First Amendment point, and you know this, I think you follow what we do, and you follow me. I don't take a back seat to anyone in terms of being a defender of First Amendment rights. We've written a lot about it at the Free State Foundation as well. But I don't think it's a proper interpretation of the First Amendment to assert, like some people do on the other side of this issue, that anything that has the effect of reducing that immunity or narrowing that immunity, the scope of immunity, is a violation of the First Amendment. What it really means is that, yes, these companies, might undergo cost. They would likely it may undergo a cost to do the monitoring, whatever. There'd be litigation costs, blah, 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 those things. But historically, I mean, they're not, that reduction of immunity, I don't think equates to a First Amendment violation. Now we do have, and this, you're familiar with New York Times v. Sullivan, famous case. That's just because you reduce their immunity. Well, let's even say that it was, I don't advocate, I don't think them not having any immunity. Newspapers don't have the same thing, others don't have the same thing, but, be that as it may.
Well, I mean, of course, New York Times,
one thing I'm going to say about
case involving an advertisement. It's someone else, posting on the New York Times, and they still got that very deferential standard in New York.
Right. That's what I was going to say. And you know how that happened? Exactly. That was the law developed that under the First Amendment. Under the First Amendment, the justices said, in order to protect the First Amendment, they did that. It wasn't because Congress passed a statute, Drew, that gave newspapers immunity from defamation suits. So we said in our comments that there have always been common law and constitutional law, citing New York Times, privileges that under the First Amendment that have existed. But I just want you to appreciate what I'm saying about the two different things.
Yeah, you're saying, if I'm understanding you're saying there's a distinction between the FCC's jurisdiction and what the right policy should be. And if I'm hearing you right, you're saying the right policy, may be to continue to grant immunity, but you're saying the FCC may have some jurisdiction.
But also, I'm saying what you just said. But the second part of what we were talking about, I'm saying as a legal matter, that's you just stated as a matter of policy. I'm saying as a legal matter, don't equate anything that Congress would do in this area or the FCC necessarily with a First Amendment violation, a free speech violation, because I've said over and over again, I said it within the past year when I wanted to promote a tweet in about net neutrality or something, and Twitter took it down. I didn't understand their policy at the time that you can't say you can't say anything about regulation. They took it down, and and I wrote something about it at the time, and I said I wish they hadn't done it. I disagree, but they're a private company, and if they want to take down my tweet because on net neutrality, then that's their right. I
would love to see that tweet, Randy. It sounds like a story there, So
well, Tom Daly wrote about it, and so you'll be able to find it.
Lead us to it. All right. Well, Randy. So I want to ask you, what's the animating principle of a think tank like Free State Foundation? And I know you obviously referenced the Progress and Freedom Foundation, which is no longer in existence. I mean, I think of think tanks. Think tanks are kind of an interesting animal, right? Somewhere between, the role of a university and the role of advocate or lobbyist. But I guess when I think of their value, it's often for a broad range of issues, and they're going to kind of help orient an educated person to the issues in this particular field. Now, we're obviously in a very specialized field of communication. So what is the role of a think tank in that type of environment, Randy? What should people expect when they go to the Free State Foundation? And what's your principle driving, policy?
Well, the principal driver really is a belief that free market-oriented policies generally promote consumer welfare and the welfare of the nation, and also rule of law principles. I mean, I'm not good at all this split screening. I don't want to lose you, but if we looked at the Free State Foundation site, it would say, our mission is to promote free market oriented policies, property rights protective policies, and rule of law principles. And later we could talk about rule of law, but but what people. So, and that most think tanks have an orientation. So, and it's good to be upfront about it, right? And that's why, and I started the Free State Foundation because I came to believe over time a significant period of time, and especially after the 1996 Act was adopted, that what I thought its deregulatory intent was not being implemented in the way that I thought it should be. And that was a motivating factor really for me, and first going to PFF and then going to start the Free State Foundation. But in terms of what people should expect, well, let me say one other thing. And again, when I was in law practice, you ask a good question. It's a completely different role, right? I needed to, and I was happy to represent, anyone that came to me. I'm glad CompuServe came to me because that was interesting for a long time, and others. But I didn't have any qualms about the role a lawyer plays in advocacy on both sides. A think tank is different, so because of the view. But let me, I'll just say one other thing. But what I hope people expect is, and what we aspire to is to do high quality work that will be impactful. Yeah.
So is the Trump administration mostly pro free market property rights and rule of law, or mostly anti free market property rights and rule of law in the space that we're addressing?
Well, in the space that we're addressing, I'm glad you added that qualifier, because if I take a broader look, I'd say, God, it's a mixed bag. But that's not what we're talking about. I would, in the space that we're addressing, I think they're mostly free market. But of course, that's attributable in large part. I mean, the one thing President Trump did that was very important, he appointed Ajit Pai chair of the FCC, and in my view, he's been an excellent chairman of the FCC, and he shares my free market orientation. So that has a lot. So that has a lot to do with how you view, if you want to put it that way, the Trump administration. And
what about export restrictions? What about restrictions on telecommunications manufacturers and the role they play in the United States?
Yeah, to be really honest, it's not something that me or someone else at Free State has followed very closely. I mean, I don't mind saying in general I'm in favor of free trade, so that's why I said that I was glad you qualified your question. I have some questions about that, but on the other hand, I'm also in favor of, I think there are legitimate national security concerns. And so some of the things that are going on with, now that I'm focusing on your question, if you're asking about some of the things relating to Huawei and others, and we haven't written about them. So I'm just going to say, this is me giving you my reaction. I'm generally sympathetic to those things because and that's because of my own views about national security and this country's need to protect itself.
Right. But so what about the Section 230? I mean, it seems to me that is also an attempt to kind of, amp the scales. Some people have talked about Section 230 as requiring a even-handedness, almost like a fairness doctrine for the internet. Do you see that? And so, what is your view of that?
No, I think that's exaggerated, because I know the fairness doctrine, and I opposed it. I don't think that's really at all what's going to develop. It's not what I would support. I don't know. I'm certainly not speaking for whatever Trump or his people would ultimately think about it. But I think that there are ways that the Justice Department, for example, I mean, they've made recommendations to Congress. I mean, there are ways, I think there's some more narrow concerns about the way that 230 operates to give immunity in certain specific instances where a lot of people would agree they're problematic. It's always a question of then how you do it, that you could target those. But I understand that I understand that if the objective of the whole 230 brouhaha is to try and somehow achieve political balance between I do think conservatives often are are, that some of these platforms don't treat them in the same way they treat the other side. But I've never said that that's a reason why that it would be something that the government should try and enforce. So if that's
right.
But there are more narrow ways you could do it. And again, what does bother me, and it's the reason a reason I filed the comments in the proceeding, was not to defend President Trump or the Trump administration, but not to just allow this notion that anything that you might do in this area is a violation of the First Amendment. That's the correct view of the First Amendment, because I don't think it is.
I want to move to another big topic here in the remaining 15 minutes we've got, Randy, and that is the issue of media marketplace, media ownership. Once again, news in this space, the Supreme Court has agreed to take the FCC's appeal of the Third Circuit decision on this matter. Now, this has gone through so many iterations. I certainly haven't followed it. I don't know. I presume that you have followed this, because this has been an important issue, at least historically, for Free State Foundation. So talk to us about the media ownership rules, the First Amendment implications in them, how they relate to the broader discussion about antitrust and the role of the FCC going forward.
Yeah, no, that's important, and it's timely. I've just got to say, to put this in context, to go back to the beginning. When I started, there were the three broadcast television networks, and no cable, and no satellite, and no internet, and all of the things that didn't exist, and your viewers. And so it's been an incredible transformation that's been good for the citizens of the country and listeners. And what's happened, the problem is that they're just really two different worldviews, and there is a view out there that has animated those that oppose any change in the regulation. We could just, there are different media ownership regulations. Let's take newspaper broadcast cross ownerships. That's a big one. Or you could have radio, TV, ownership prohibitions. There are those who honestly oppose every single change, and their view is they talk about scarcity of media outlets, media voices, and a lack of diversity of viewpoints. Now, sometimes there's also a discussion about diversity in the sense of whether minorities are fairly represented. But right now, for the moment, I'm talking about a lack of diversity of viewpoints. And they have that view. And honestly, I just can't. It's hard for me to give credence to it. I disagree. There's so many voices that I've heard, and the regulatory environment has just been slow to change. Now, in this case, a lot of it's been stymied by the Third Circuit. That's where these decisions have gone up, but they should be changed. And then one thing that we often have written about, that I've often written about, my colleague Seth Cooper has done a lot of good writing about this, with a lot of these various media ownership restrictions that apply, is that there's a First Amendment overlay here. You want to talk about the First Amendment. When you restrict on the basis of view that there's a scarcity of media voices, and you're restricting companies from arranging their ownership and their relationships like they want to me, that implicates really First Amendment values. It's not necessarily the current jurisprudence of the Supreme Court, but I hope that one day it will be. I mean, here's a good example of that. Let me give you the good example. You take the must carry rules, that were adopted in 1992, in the 1992 Cable Act. They went up to the Supreme Court, and they were upheld on the 5-4 decision in the Turner v. FCC case.
Turner won.
Turner won. Then there was a Turner 2, but the import of those cases, Drew, was that the cable companies had a bottleneck, that prevented other sources into the consumer side, or had a bottleneck. That was the word that was used in Turner 1, Turner 2. Whatever the situation was at the time, and assuming that made sense at the time, and it was decided on First Amendment grounds. The court had this balancing test. Now I don't think it makes any sense. I think rules that are must carry, forced access, I must give access. You don't have to give. I appreciate being on here today, but you weren't under an obligation to have me a legal obligation. You control your site. I know you're not a broadcaster. I know what all the broadcasting law used to be, but I don't think it makes sense. And I think it violates at least the spirit of the First Amendment for those that want to, talk about the First Amendment.
Well, so really, isn't this last decade or even 2 decades ago issue? I mean, you almost wonder this might have made an impact 15, 12, 13 years ago if media ownership rules weren't stymied in the way they were by the Third Circuit. But I come back to, is this really where the landscape is, or is it still important to kind of clean up the underbrush and at least let these broadcasters consolidate so they've got a fighting chance against the tech industry? I mean, that may be another way of doing this, Andy. What are your thoughts on that?
Yeah, no, I think that is part of it. I mean, I'll confess, we just because of we only can work in certain areas at certain times, whatever. We haven't taken a deep dive into some of these issues recently, and they do change. But take the newspaper broadcast cross ownership rule, and again, this is based mostly on studies others have done. But I think there are a lot of failing. There are newspapers and broadcast stations that otherwise, probably could exist, but for the fact that they're prohibited from consolidating operations, and with Amazon, Google, Facebook, bless their hearts, they've done a lot to promote consumer welfare. I don't want anything I've said today to take away from that fact, but they're pretty powerful platforms, right? So you do have to recognize that a lot has changed, and the internet has been a lot of that. And I think some of the arguments, and a lot of people making these arguments, I consider them my friends, and I respect them. You can take someone like Commissioner Copps. I like him a lot. I hope he would say the same about me. But I think his view is nothing's changed. There's scarcity of media, and I just think it's blinking reality, as we say.
Well, you raised this issue about the tech companies and the power of the tech companies, and you've also said consumer welfare, right? They've promoted consumer welfare. This is not the organization you're associated with now, but Progress and Freedom Foundation was, of course, one of the leading advocates of a Microsoft breakup. They were very, very vigorous and promoting. And this, in some people's minds, went, askance on their general free market approach. They were free market, but they were also pro-antitrust against Microsoft. So let me ask the same question of you today. I mean, is there a strong or a weak antitrust case from a free market perspective against the newer dominant players on the tech world?
Well, I would be very careful about, the case. I think it would have to be strong. I'm not convinced really at all, and I haven't read this recent House report that came out at all yesterday. But I haven't advocated. I'm wary of just willy-nilly saying let's break up these companies. I would say that. And I think in retrospect, that I didn't work on any of that Microsoft work while I was at PFF and breaking up. So this is a good case where, as I said earlier, the policy, the principle we follow at the Free State Foundation is we all speak for ourselves. But I bet the authors, the people doing the work now might, in retrospect, take the view that maybe the breaking up Microsoft, the notion of doing that was not a good thing. But I shouldn't speak for them, having said what I said. So I would be wary of that, doing that, but I don't want to rule. I'm not saying that there shouldn't be anything that's done. They are pretty powerful.
There's still a need for antitrust investigations of action of monopolization of the market, right, Randy? Or
no, there is. I mean, as long as we have antitrust laws and we have agencies charged with enforcing them.
I mean, that's basically, to go back to the beginning, that's what you said we should do with the FCC. For the most part, we should make it an antitrust level analysis as to whether there could be kind of regulation of the activities of any of these technical functional categories, cable or wireless or telecommunications, right?
Yeah, no, I did say that that for the most part, putting aside the spectrum, technical aspects of regulating spectrum right now, that for the most part, we should apply an antitrust-like analysis. And then I also said, although I was I was somewhat lukewarm about this, but I said I think there's still a case to be made for maintaining the FCC as a special agency with specialized knowledge to apply that type of analysis. So yeah, no, I agree with that. But here's something else I've said that relates to all of your wonderful questions. About sort of the way I think about these things now, Drew, is that because of all these changes we've talked about, I think that, and you can craft this, I think, in a new act as a legal proposition, that there ought to be a presumption, a rebuttable presumption, not irrebuttable presumption, that absent clear and convincing evidence otherwise, that you don't regulate on a public utility basis. Again, we can talk about Lifeline and universal service, but you don't regulate absent market failure or consumer harm. And that is that's an antitrust type of standard. So I don't have a problem in saying that quite clearly.
We've got 2 minutes left, Randy, and we haven't talked about the coronavirus and broadband. So I want to give you an opportunity to say a couple closing remarks about what we've learned about broadband through our pandemic of the last 6.5 months. Right. What does it say to what should happen in broadband policy?
Good. That's a good way to close. I mean, I think for myself, and I think this is true of a lot of others, but speaking for myself, it's heightened my sensitivity really to the importance of broadband. And I think I'm someone that had some good sense about it after all these years. But nevertheless, when you have this lockdown, when you've had a lockdown like that, it makes you understand the importance of it. So I think I could take from that I'm more sympathetic than perhaps I was 7-8 months ago to certain government actions that, in the right way, targeted way, proper way, do what we need to do to try and fill these remaining gaps. One thing that you may know, I think, I bet, I've been for a long time, 2 decades or more, a proponent of Lifeline service. A lot of other people that call themselves deregulatory or free market might not, but I've been consistent in that. And the reason is, it's always been my view, even with the broader free market orientation, that there ought to be a safety net, for people that need that help to have communications available, just like we have safety net for food stamps and other things. So I've always taken that position on Lifeline, and in thinking about now where we are in COVID, it's just an extension of sort of that type of thinking that makes me, and I think a lot of others realize it's important to do what we can to get access, to those that don't have it. There's going to be some people that, for different reasons, don't ever want it, and we live in a free country, but we can do more. We can do
Great.
more.
Well, we'll have to let that be the last word. Thank you so much for being with us, Randy, and for each of you, our viewers, for joining us for this final, for now, Champions of Broadband series. Stay with us next Wednesday at 12 noon Eastern Time. We will begin our new series called A No-Nonsense Guide to 5G, and you can learn more about it at broadbandbreakfast.com. I'm Drew Clark, editor and publisher, and I will see you next week.